Welcome to today's webinar, OSHA Basics for Small Business, Understanding Federal Requirements and Inspections, brought to you by the NFIB Small Business Research and Legal Center. To our current NFIB members, thank you so much for being an active participant in the small business conversation and for your continued support. To those who are not yet members, welcome and consider joining the nearly 300,000 small business owners who are fighting for small business with NFIB. Our success is based on strength in numbers. Each new NFIB member makes our voice a little louder and strengthens our efforts to fight anti-small business legislation. If you are or know a small business owner who needs their voice to be heard, visit NFIB.com or call 1-800-NFIB now. Before we begin, here are a few reminders. If you have any issues with audio, please ensure your computer speakers are set up properly and know that your internet connection does affect the clarity of sound. We are recording today's presentation, and after each webinar, all registrants will receive an email with a link to the recorded webinar and link to download the slides. We encourage you to enter questions in the Q&A box on the right of your screen. Just click Ask a Question and type your inquiry. We will address questions at the end of the program. And while we typically get many questions during these webinars, even if we don't get to your particular one, we hope we will answer one that will be helpful to you. And now let's meet our speaker for today. Felicia Watson counsels and represents management clients on labor and employment law matters. Prior to joining Littler, Felicia was Assistant Vice President with the National Association of Home Builders Office of Legal Affairs. She focused on construction liability, labor, safety and health, privacy, and international trade. Her background also includes experience with 2 Washington, D.C. area firms. She previously served as Deputy Prosecuting Attorney, prosecuting felony domestic violence cases and providing evidentiary training for local law enforcement. Felicia is a certified information privacy professional. And now I'll hand things over to her. Thank you so much for speaking with us today.
Good morning or afternoon, depending on where you are. Thank you so much for the invitation to speak. Today, I'm going to be covering what to expect during an OSHA inspection. We know that when the government shows up on your website, that can be extremely intimidating. And so today, I'm going to cover these topics: OSHA inspections, the types of inspections that you can anticipate, some ideas and tips for how to prepare for an OSHA inspection. What happens once OSHA shows up? What do you do? What are some considerations that you want to have in mind? And then finally, we're going to wrap up with some post-inspection considerations. And I do appreciate that several attendees registered with questions in advance. And so we hope to get to the questions that we can at the end. So first of all, it should come as no surprise that OSHA as a government agency has limited resources. It simply can't inspect every workplace. So to pull back the curtain a little bit for you, the agency has established a system of inspection priorities that are designed to ensure that maximum feasible protection is provided and the worst situations are inspected first. So what does that mean for you? Well, there's several different types of inspections. The first type of inspection that OSHA may do is an imminent danger inspection. This usually occurs after OSHA receives a report that a condition of imminent danger exists at a workplace. Imminent danger inspections are given the highest priority and are usually conducted the same day the condition is reported, or no later than the next regular working day. If OSHA can't make it on site in a timely manner, the agency may provide advance notice of an imminent danger inspection in the hopes that the employer will address that imminent danger. The next in priority with respect to types of inspections occurs if there's a fatality on the work site or there's an accident that has occurred. OSHA can inspect your work site if the employee is killed on the job or suffers a work-related hospitalization, amputation, or loss of an eye. Timing-wise, OSHA is often on site the same day if it's a fatality. For a reportable accident, it may be a few days before OSHA shows up, but rarely more than a week. And as an aside, and yes, we're already going off course because that's how things come up. But something to be aware of is, how does OSHA know when you've had a fatality or a reportable injury at the work site? Well, as an employer, you're required to report a fatality to OSHA within 8 hours. An inpatient hospitalization, amputation, or eye loss must be reported within 24 hours. So that's usually one indication of how they know to do an inspection. And this is for federal OSHA jurisdictions, and certain state plans, you should be aware, have a shorter timetable to report. Also, first responders that come out to the scene are also mandatory reporters. And so they might also be required to submit a report to OSHA. And so that's another way that they would find out about a serious injury or a fatality at your work site. But OSHA has other means of learning this information as well. OSHA may also receive notice of a fatality or accident through media reports or healthcare officials, as I just mentioned. So this isn't a situation where if you don't report, OSHA's not going to know about it. They will definitely know, and penalties can come from failure to report within the required timeframes. And then the next type of inspection is based on a complaint. And so what does that mean? That means that after an employee or an employee representative has filed a complaint with OSHA alleging a violation of an OSHA standard or identifying potentially unsafe or unhealthful working conditions that the employee feels need to be addressed and investigated, then they may file a complaint with OSHA. And they can do this at the federal level if they're in a federal OSHA state, or they can do this at the state level. Usually there's an online reporting system, there's phone numbers that they can call, that type of thing. And with some of these complaints, OSHA will conduct what is referred to as a phone or fax investigation. And that occurs when OSHA will telephone the employer, describe the alleged hazard, and then follow up with a fax or letter requesting additional information. The employer is required to respond within 5 days, identifying in writing any problems found and noting any corrective action that they have taken or plan to take. This is always preferred because in those circumstances, OSHA is never actually on the site. So you have the ability to do your own inspection, see what needs to be corrected, and address that. In other cases, OSHA will inspect the work site. They'll actually come out to your site. In these inspections, OSHA should provide a copy of the complaint, but it will redact or remove the identity of the employee filing the complaint. And some states may take this more literally, so that is something to be aware of. The next type of inspection is a programmed inspection. These occur based on objective neutral selection criteria. This is a random inspection that OSHA conducts to verify compliance with OSHA standards. Programmed inspections are scheduled based on objective or neutral selection criteria, and OSHA selects work sites according to national scheduling plans or under local, regional, and national emphasis programs. You might be wondering, what's this emphasis program? Well, if you're asking yourself that question, it's a good thing you're here. National emphasis programs focus on establishments in industries that OSHA considers to have potentially high injury or illness related rates that are not covered by other program inspection scheduling systems. So, for example, currently, one of OSHA's national emphasis programs involves heat, injury, and illness prevention in outdoor and indoor workplaces. And while they don't have a regulation on that, they are basing their inspections on what exactly is going on in a particular area. For example, Texas, if it's hot in Texas, they might do national emphasis programmed inspections for construction sites that are where you have workers working outdoors in the heat. So that's an example of one. And OSHA can use these to establish alternative scheduling procedures, and they can be established on a national, regional, or even a local basis. And so if you are concerned about these types of programs, you can get a sense of what national emphasis programs and local programs are under OSHA's watch by going to the OSHA website, osha.gov. In addition to the initial inspection, OSHA's compliance officers must also conduct follow-up inspections to ensure that hazards are being corrected and employees are being protected. So for instance, something that could trigger a follow-up inspection would be if an employer fails to respond to a request for certification of abatement. And what does certification of abatement mean? That means that they've identified a concern or a problem at your work site, and they require you to abate or correct that problem problem by a certain date. And if you don't respond and give them evidence that you've corrected that, then they will do a follow-up inspection, which could lead to additional penalties for failure to abate if you've been cited for an instance. So these are all things to keep in mind as you are considering your operations. And so why does all of this matter to you? Because OSHA has certain monetary penalties that are set every year, and they base it on what's going on with a producer price index and other economic data. But as of January 15th, and they do update these annually, the maximum penalty amounts for OSHA violations are these. So a serious and other than serious and posting requirements, the penalty there is $16,550 per violation. Failure to abate, as I just mentioned, that would be $16,550 per day beyond the abatement date. And then a willful or repeated citation would result in a penalty up to $165,514 per violation. So if you have several repeat or willful citations, you understand that these penalties can climb very, very quickly. And you do need to be aware of these. So what are the hidden penalties that come with an OSHA citation? In addition to the monetary penalties that I just showed you on the previous slide, they're not the only consequence that you might face as a result of an OSHA citation. And some of these non-monetary penalties can have a far more significant impact, including cost of abating or correcting a hazard. You might incur additional costs for fixing those problems that were identified. You might need to provide additional personal protective equipment, that type of thing. Reputational harm to your company. You might incur a loss of potential contracts if you do any government contracting work or any state or local contracting work. That might affect your ability to get future contracts or even just work as a subcontractor for a general contractor in a depending on what your business is. You will likely face higher insurance premiums, and you also have the increased oversight and or inspection risks, right? Once they've come out, if you haven't corrected these problems, or you come out and you resolve something, you may be subject to further inspections or oversight by OSHA, depending on what the circumstances are. You could also potentially face criminal liability for willful citations. And so in that instance, that would mean that the Department of Justice would come through and potentially prosecute you for criminal liability on some of these issues. And then finally, OSHA's Severe Violator Enforcement Program, where you might be a repeat or deemed to be a repeat offender or violator of these OSHA standards. And so at that point, if you end up on OSHA's Severe Violator Enforcement Program, that means that you're subject to more inspections, additional oversight by the agency. They might require certain plans to be put in place, implemented periodic inspections more frequently than normal. So these are all things to think about with respect to your compliance requirements. And so, all right, all of that doom and gloom, how do you prepare if OSHA for a potential OSHA inspection? Now, remember, I did mention at the beginning that OSHA has limited resources. That doesn't mean that they won't come out and do an inspection. And so not all of these are announced in advance, as I mentioned. And so this is something for you to think about proactively to protect your business. So one of the things that you can think about is designating a point of contact, right? You can still prepare even though you don't know necessarily that they're going to come out. If you have to report an accident, you should be prepared for a compliance officer to show up at your doorstep. And if they don't, okay, no harm to you, but you at least need to go through and do what you can to prepare. And if they do show up and you're not prepared, this can lead to citations with substantial penalties. Therefore, it's critical you really need to have a plan in place and personnel at your work site that are trained in advance on your company's OSHA inspection procedures. So what does that mean? What can you do to prepare in advance? You can designate a point of contact. Each facility or each location should designate a point of contact at the work site. This individual's primary responsibility is going to be to interact with the OSHA inspector during the inspection. And here it's imperative that this individual understands the OSHA regulations and the inspection process. And so you're thinking, well, I have a safety person at my work site, but that might not be the first initial point of contact. Maybe you have a reception desk, and that person needs to be trained on what to do when OSHA shows up, who to contact immediately when OSHA is on the site, and to have that person have the OSHA inspector wait until the designated point of contact can get there and speak to the OSHA inspector. So some slightly different layers here, but things to think about, right? You also want to maintain your records and safety programs. OSHA inspectors are typically going to ask to review the current and past 3 years worth of OSHA 300 and 300A logs. Likewise, inspectors will likely ask to see any required workplace posters and various safety programs such as hazard communication if you're using any chemicals on site, lockout, tagout, how do you control hazardous energy to serve and to repair machines, and emergency evacuation procedures. So these records, posters, and safety programs definitely need to be kept up to date. And they may also ask for employee training records too, depending on the nature of the inspection. So you want to be able to have current records available. You also want to update and make sure that your company policies are current. Third parties who may join a walk-around inspection, which include the OSHA inspector and potentially employee representatives, should abide by the same worksite rules that visitors and employees are required to follow on the worksite. So this includes policies related to personal protective equipment, safety orientations, and no solicitation and no distribution policies. So for example, if you have a worksite where employees need to put on personal protective equipment before going to a certain location, you're going to need to make sure that those policies are up to date and that you require the OSHA inspector to also don that equipment, and any employee representative who comes there to go through the walk around with the OSHA inspector. They should not be allowed on site without that personal protective equipment. And then you want to proactively determine who that employee representative will be. While there's no single process by which employees may designate a walk-around representative, an established safety committee comprised of current employees can pre-select the employee walk-around representative. If you have a union represented work site, then in that instance, usually there is the employee representative, the authorized employee representative from the union who would serve that role. But for those work sites that are smaller or don't have a union presence, this is something to think about, and have this person identified, pre-selected, because that way you've got that representation and you're not scrambling at the last minute for that. Just some things to think about proactively. Even if OSHA never shows up, consider putting all these ideas into place so that you can be ready to go just in case. All right, so OSHA's here. Now what do? You definitely want to notify that point of contact. When OSHA arrives, a supervisor should politely greet the inspector and ask for their credentials. The point of contact should be notified immediately thereafter. And so while waiting for the point of contact to arrive, the supervisor should escort the inspector to a nearby room where they are not able to observe any violations. The inspector can wait a reasonable amount of time. What does that mean? Is that half an hour? Is that 15 minutes? Is that 20 minutes? Usually those are pretty reasonable. Anything more than an hour could be potentially problematic, but it depends on the circumstances and where that point of contact is coming from. You want to determine the reason for the inspection, right? We talked about that generally, the types of inspection that OSHA will do. They'll inspect a work site for one of two reasons. The company has reported a serious injury or fatality, or there has been a complaint. If the inspection is based on a complaint, you should do what you can to obtain a copy of that complaint. Remember, I said that OSHA may redact or black out the information on who the person is who's complaining, but that's okay. You still get a copy of the complaint, so you know what the basis for the complaint was. You also want to limit the scope of the the inspection, right? This isn't a tour where you're taking them all through the plant. Let's say you've got a manufacturing facility. You're not walking them all the way through. If the scope of the inspection is one particular section of the plant, that's where you want to take them in the most direct route possible. But if that can open you up to potential plain view violations where OSHA inspectors see something that's in plain view as you're walking them toward that location, you could be subjected to additional citations, even though the scope of the inspection initially doesn't cover that. So that is something to keep in mind. Anything in plain view, they can issue a citation for regardless of their reason for being there. So again, don't give them a tour. Even if you have to walk them outside your building and over to the section that they want to see, that's perfectly fine. You're just not going to give them a tour of the whole facility because then you have expanded the scope and opened yourself up to potential additional citations. You also want to make sure that you escort the inspector. Don't just let them go and be on their own. The point of contact is the person that should accompany the inspector throughout the walk around, and you should escort them to the defined area via a route where it is, as I mentioned, unlikely that a violation will be observed, and that minimizes contact with other employees, which may mean, as I said, walking outside. And you shouldn't offer any information during the walk around, and any small violations that are seen as you're going should be fixed immediately. You also want to mirror the inspector. So what does that mean? The inspector may take photographs, videos, or measurements during the walk around, and these should be allowed unless there's a trade secret or security issue. If there's a trade secret, you should identify that immediately to the OSHA inspector. And the point of contact should take side-by-side photographs, videos, and measurements. So essentially what the inspector is doing, the point of contact is doing. And so sometimes it may be difficult for the point of contact to do that. So, excuse me, so an option for you is to identify someone to accompany the point of contact. So you may have two employees that go with the inspector, the person who serves as the point of contact and the employee who is doing the mirroring, doing the videos, doing the photographs, and the same sampling or measurements that the OSHA inspector does. You should also document any observations made by the inspector and your conversations with the inspector. So these are all things that are important because you want to be able to identify all this information and what they focused on. So, all right, you've gotten through that. Now post-OSHA inspection, what are some considerations for you to think about? First of all, the document requests. The OSHA inspector will request documents. Any documents should be put in writing, any document request, excuse me, should be put in writing and sent to the point of contact. You should only provide those documents specifically requested by the investigator, and you should maintain a record of all documents that you provided or that were reviewed by OSHA. You also want to, because these are potentially subject to Freedom of Information Act requests, any documents you provide should be marked as confidential business information, trade secrets. Because otherwise, if you don't, I flag these documents in such a manner, anybody can submit a FOIA request and get a copy of the documents that were provided to OSHA as a result of the document inspection. Employee interviews, this is another thing to anticipate. Interviews, the inspector may want to interview your employees. They do not have the right to pull your employees while they're working unless it is safe for them to do so. And you can ensure that there is someone else available to cover that employee's job tasks. If there is no one available to cover that employee's job tasks, you can postpone that interview or schedule them to speak at another time. And then something else to keep in mind is the OSHA inspector may want to speak with management, but they should not speak with any management employees without a company representative or counsel present. And why is that? It's because as a management employee, anything the management employee says applies to the company. So a management employee may inadvertently concede something or say something that will end up binding the company based on the management employee's statements. So that's why it's always good to have a company representative or counsel present during those management interviews. And then the next thing post-inspection is there's a closing conference. And at the conclusion of the inspection, OSHA should conduct a closing conference. And I say should because there have been many inspections closed and citations issued without a closing conference being held. But the closing conference may be conducted in person at the employer's work site, or it could even be conducted by telephone. Most closing conferences are conducted by telephone, not usually the same day as the inspection, but it depends on the circumstances. And at the closing conference, the compliance officer can review the apparent violations and other pertinent issues, if any, that they found during the inspection, including getting input for establishing abatement dates. When you are going to correct the apparent hazard. There are certain do's and don'ts, though, at a closing conference that you should be aware of. And this is really the time for the employer to learn about potential citations that the compliance officer is considering. Listen carefully to the compliance officer's findings. You can ask for specific information supporting an alleged violation, and this information can then be used to put together your strategy to respond to the forthcoming citation. Try to determine if OSHA has all of the documents that they requested. To the extent a forthcoming citation is based on a lack of documents, it could be due to a misunderstanding of what was requested, and you may be able to avoid a citation by providing the missing documents. So that's something that's important to follow up with them on. Ask about hazards that need to be abated, right? By promptly abating hazards, this can serve, one, as a basis to reduce the potential penalty, and two, it can avoid the time crunch that may come from a short abatement deadline. And finally, do not argue with the compliance officer. There's a time and a place to argue your position, but it is not during the closing conference. And then finally, citations. If you receive citations, you have three options. You can schedule a meeting with OSHA. This is called an informal conference. You can also contest the citation or simply correct the hazard if required and pay the penalty. The file stays with the area office for 15 working days from the date you receive the citation. So this is your window to make your decision. You can have your informal conference. There's little downside to scheduling an informal conference. These can be held in person or via Zoom or Teams. This is where you can argue your position, why a citation may be inappropriate or should be reduced. I found that OSHA generally is willing to make some concessions during the informal conference, but that depends on the citation. You can attempt to change the classification to reduce a penalty or even discuss abatement during this informal conference. If you can reach an agreement at this time, then OSHA will usually put together an informal settlement agreement that can be signed by both parties, and that would resolve it depending on what the penalties and the citations would be. You could also contest the citation. If you don't reach the agreement that you're hoping for during the informal conference, you can still contest the citation. But keep in mind, your notice of contest must be filed within 15 working days of when you receive the citation. In other words, scheduling an informal conference does not extend this deadline for you, this 15-day deadline to file your notice of contest. Once you file that notice of contest, the file will be sent to the Occupational Safety and Health Review Commission, and then you'll litigate the citation. So that 15-day deadline is something to be aware of. It's very important consideration for you. And so what are your takeaways here? Some of your key takeaways: you really want to be proactive before OSHA arrives. You don't always know when they're going to show up. As I mentioned, there can be different types of inspections. You can have a programmed inspection. You can have an inspection that results from an employee complaint or from an accident or a fatality. I would say that if you do have an accident or a fatality on your job site, you should expect OSHA to show up. It's just the timing on when they show up that will be important to you. And that may determine, what your steps are, but you need to be aware of those. You want to have these procedures and policies in place in advance, right? We talked about making sure that your safety policies, all your procedures are squared away. Your safety programs are up to date, your records are up to date, any training records as well. Make sure all of your OSHA logs are up to date, your summary logs, your incident logs, your injury illness logs. You want to train employees, including whom to contact if OSHA shows up. If you have a desk, a reception desk or something like that, that person needs to also be in on the training, because they're going to be reaching out to your designated point of contact immediately. They can have the OSHA inspector, take a seat in the lobby, get them a cup of coffee, or direct them to, a conference room, that type of thing. So your initial person who's on site, if it's a receptionist, that person also needs to be included. Proactively designate an employee representative as well. In addition to the designated point of contact, you also want to designate an employee representative. Make sure that that person is available to accompany the OSHA inspector. Identify a third person to accompany the OSHA inspector and the designated point of contact to do the mirroring, right? To take the notes, to take the measurements, to take the same photographs that the OSHA inspector takes. And then obviously something that's really important is to reach out with questions to your attorney for assistance. And so you wouldn't reach out to your family law attorney, you wouldn't reach out to your business attorney. You would definitely want to reach out to an attorney that is familiar with OSHA and the OSHA requirements. These are all things that will help you in deciding how you want to move forward. If you want to contest your citation, if you don't want to contest your citation, keep in mind that if you get a serious citation, that if you have the same or substantially similar citation or incident in the future, then that could be treated as a willful or repeat violation, which means your penalties are higher. So really think about what type of citation you receive, what are the circumstances, and how you want to handle that, because these things can pile up and be considered repeat or willful in the future if it's for the exact same type of situation. And with that, I will stop sharing my screen, but also just, be able to take additional questions for anybody that may have them. And so I know that, go ahead.
Oh,
I'm
go
sorry.
ahead. I'm sorry, Felicia.
No, I was just going to say, I know that I had mentioned earlier, and we had mentioned this, that several attendees had submitted some questions in advance. So I thought quickly, if you don't mind, Beth, that I would just kind of go through those really quickly.
Oh, that would be great. Thank you,
Okay.
Felicia. Yeah, please start with those. And I will just say too, I think we probably will have time we've gotten some in the live event Q&A,
Okay.
but I think we might have time for some others too. So if you have a question, feel free to go ahead and type it in the live event Q&A chat box. Okay, Felicia, the floor is yours.
Okay, great. Thank you so much. So for those states, I had mentioned reportable and recordable incidents. And so we did get a question in advance. What's the difference between those? So reportable means that employers must report any worker fatality within 8 hours. You have a really short time window there. And you have to report within 24 hours any amputation, loss of an eye, or hospitalization. So those are really specific deadlines to be aware of. And you can get a citation for a failure to report in a timely fashion. Even if you're 2 or 3 hours over one of those deadlines, OSHA will cite you for that. So do be aware that is a reportable incident. The other word that is used is recording. What is a recordable incident? So many employers with more than 10 employees are required to keep records of serious work-related injuries and illnesses, right? So certain low-risk industries are exempted based on your national NAICS code, your industry classification code. And there's information on OSHA's website, osha.gov/record keeping, that can provide additional information on whether you're exempted. And so there's 3 forms for record keeping. You've got your OSHA 300 log regarding injuries and illnesses. And if you have maybe 2 or 3 locations, you have to do a 300 log for each location. And this is used to classify the work-related injury and illness and the extent and the severity of each. It's used to record the specific details about what and how it happened. It involves loss of consciousness, restricted work activity, job transfer. Let's say someone is injured, they can't do their job, you transfer them to another job for 10 days, days away from work, or medical treatment beyond first aid. That's what you would keep on your 300 logs. 300A, those are your summary of work-related injuries and illnesses. That just provides a summary. All establishments covered by Part 1904 must complete this, even if no work-related injuries or illnesses occurred during the year. And so again, this falls into, are you one of those exempted industries? And if you're not, based on your national classification code, then you would need to keep these logs available. 301 logs, those are your injury and illness incident report, and that is filled out when a recordable work-related injury or illness occurs, and you have to do that within 7 days, and you have to keep these records for 5 years. So that's just the difference. Record keeping is just keeping records, and reporting is when you have an incident that meets one of those requirements. But keep in mind that some states require a shorter time frame for those types of instances. And why does that matter? So one of the other questions that's kind of related to this is, if you are in a state that has its own state plan state, are you still covered by federal OSHA? Yes. And the reason you are, and we had a couple of questions from attendees in Washington, is that the Occupational Safety and Health Act was adopted in 1970. And at that time, Congress allowed states to develop their own state plans as long as their own state plan is at least as effective as federal OSHA. And so what does that mean? So Washington State, for example, they got initial approval of their own state plan in 1973, and then it was formally approved in 1982. And there are about 21 states and Puerto Rico that have their own state plan states. Those plans have to follow federal OSHA, but then they can also be more protective and provide more requirements. So for example, in Washington State, fall protection height is 4 feet, not 6 feet. That means they can be more protective than federal OSHA. Federal OSHA, excuse me, is the floor of what is required. And then when federal OSHA adopts new regulations, the states that have their own state plans have 6 months to bring their own plans, their own regulations into compliance. And again, remember that if you're in a state plan state, then it can be more protective, more restrictive from an employer's perspective sometimes. So that's why it's really important to be aware of what those reporting requirements and recording requirements are. The minimum is federal OSHA that I've gone through. So something else, another question that we received is, Washington State, would Department of Labor and Industries inspection be handled similarly? And the answer to that is yes. All the states that have their own state plans have to have same type of enforcement, same type of procedures. They just maybe do additional regulations. So that process of doing an inspection would be the same. They're not going to announce in advance. They may do a programmed inspection, but not very often. It's usually complaint-based or as a result of an accident or injury. And this applies to all the states. This is how they'll address these inspections. We got another question about indoor temperature requirements for food trucks. And then if they apply, is the owner the only one working with no employees? And what about if they have one employee? So there are no specific federal regulations for food trucks, but under OSHA's general duty clause, employers are required to provide a workplace free from recognized hazards, including heat. And you know, earlier in the presentation, I had mentioned that national emphasis program, and I had mentioned that OSHA had a national emphasis program for heat for indoor and outdoor workplaces. And so that is a circumstance where under the national emphasis program, OSHA has recognized that heat is considered a recognized hazard. They've recognized that as a hazard since 2011, but they adopted a formal emphasis program in 2022, and they just extended the application of that national emphasis program until 2026. So with respect to temperatures, there's no specific requirement inside under OSHA. Now you might have FDA requirements for keeping food at certain temperatures, but that's not really, I don't believe, the gist of the question. So OSHA's working on a regulation on heat, indoor and outdoor heat environments. It's not been finalized. They're still in the process. Likely by the end of this year, if they really get their act together and move quickly. If not, probably something next year. I hope I haven't jinxed it and said it's coming this year. If the owner is the only person there and they don't have any employees and they're self-employed, then they're not covered by the OSHA regulations. But even if you have just one employee, then you are covered by OSHA. And so that is something to factor in. Another question that we got early was the requirements for less than 5 employees. And they didn't talk about the type of business, but is there any place to look up at any time to make sure nothing new has been added so you can stay current with the requirements? And then do the requirements change on the status of businesses, whether it's a sole proprietor, a limited liability company, a corporation, S Corp? Let me take that one last. OSHA requirements do not change based on the business classification. If you're a sole proprietorship and you have 2 employees, you're covered. So that is something to keep in mind. OSHA regulations still apply even if you have less than 5 employees. Now, I'm presuming that there are no farms here. OSHA standards applicable to farms is really more nuanced, especially when family members of farm employees are concerned. And so that is not something I'm going to discuss today. However, otherwise, if there are family employees and it's not a farm situation, they would still be covered by OSHA. So just because you've got your sister and your sister-in-law and your sister's children working for you, you're still required to follow the OSHA regulations. And so that is something to keep in mind. Farm notwithstanding, I'm not prepared to really get into that today because I wasn't sure that there'd be enough time. And then if you want to stay current, you can subscribe to OSHA newsletters that will send out information and updates, particularly when pending rules are coming. And so, or you can also get a sense on what OSHA is focused on. One of their newsletters is Quick Takes. I subscribe to that, but OSHA.gov, www.osha.gov has a lot of information on their website. You can use that to search. Sometimes you get really decent search results based on the terms that you put in, and sometimes you get random stuff that isn't always helpful. But there's a lot of information on their website. And if you do need compliance assistance, federal OSHA does have compliance assistance programs where you can have them come out and walk you through. Just because you get their compliance assistance doesn't mean that in the future you might not be subject to an OSHA inspection. If you're thinking about doing a request for compliance inspection or compliance assistance, my recommendation is to consult with your local OSHA attorney first before you do something like that, just to get a sense of where you are compliance with the OSHA regulations that apply to you. Another question that we got is, do I need an attorney, to contest an OSHA citation? Not initially, but I think it's often a good idea to get assistance with this process as soon as possible, as the deadlines and requirements are strict. Something to keep in mind, I mentioned if you file a notice of contest to a citation, you've got to do that within 15 days of receiving the citation, and that's 15 business days. It doesn't count federal holidays and it doesn't count weekends. But if you're going to contest that, you need to be aware of those deadlines. If you miss your deadline, you're done. There's no ability to appeal that. The citations are deemed admitted, and then you have to pay the penalties, and you cannot then reopen that to challenge that. And even if there's some type of a hardship, you can argue that you're prejudiced by that, but generally the review commission is not good at reopening any of these if you miss your deadline. So I think it's really important to, depending on the nature of the citations, to get legal assistance from an OSHA experienced attorney to help you, just to make sure that you don't give over too many documents, that you give them the documents that they're looking for, to assist you with marking the documents as trade secrets and confidential business information, to make sure that that's all covered. So these are things to consider. Obviously, it's a business decision. If you get an other than serious citation, or it's a paperwork related citation, and that's all you got, do you necessarily need an attorney to assist you with that? that's a business call that you'll have to make, a business decision that you'll have to make. The idea there being, is it something that is capable of repetition, that you could get additional penalties for not addressing whatever that other than serious or regulatory violation turns out to be. That is something to keep in mind. It's not always necessarily the first set of citations you get. It's the potential for being cited in the future for a repeat citation or a willful citation. So that is something to keep in mind. And then another question that we got in advance, this person has between 10 and 15 employees. Do the requirements change depending on the time of year if they hire more employees during the summer? So this actually doesn't apply to OSHA requirements generally, but this may apply to whether or not you have to keep OSHA injury and illness records. So if you have 10 or fewer employees at all times during the last calendar year and it never went over 10, you do not need to keep OSHA injury and illness records unless the Bureau of Labor Statistics or OSHA inform you in writing that you need to keep these records. And occasionally BLS, Bureau of Labor Statistics, will send a request to an employer saying, normally they're not required to report and record these records or record this data, but they will occasionally send letters to employers saying, keep these records for a year and then submit them. And so unless you get something in writing and you fall within that 10 or fewer employees, you generally do not need to keep these records. If you have an injury or illness that is recordable, then you do obviously need to make that record. You still need to comply with the OSHA requirements regardless of your business size, unless you are a sole proprietorship and you have no employees. And so those are the questions I received in advance. But I am happy to take other questions as long as they're not too difficult.
Okay.
Give me easy
We
ones.
have
No,
more
I'm kidding.
questions. We have a lot more questions, Felicia. So first of all, I want to just mention too that I actually, in the chat box there, I dropped the link for participants to sign up for Littler's newsletter, which I receive. And you can actually then, when you subscribe, you can check off specific subject matter. So if you're just interested in occupational safety and health, information materials, then you can check that off. But the Littler newsletter I find very informative too. And of course, I want to thank Felicia for taking the time to offer this great presentation, and also Felicia to thank Littler. NFIB works very closely with Littler, and we've been fortunate to be a client ourselves of Littler. Littler has represented NFIB in a number of lawsuits and challenges to federal regulations. So we are very grateful for our partnership with Littler, and thank you for taking time today. But let's go on to some more of the questions here, because they keep coming in here. And I think this is one that bears repeating, and I know you've covered this already, Felicia, but it's come in twice in this chat box here.
Okay.
I've been told, due to the size of our company, we do not have to follow all the rules OSHA requires. Is this accurate?
No.
There's no small business exemption, right? That's what I would like to say.
No, and that was one of the questions we got in advance was, if I have 10 or fewer, do I need to do X? Well, that regards the recording requirements. If you're in construction, you're going to be one of those industries that's required to report. So you really need to find out if you qualify for that limited exception for doing your OSHA 300, 300A, 301 logs. And there is a link on the OSHA. Actually, it's osha.gov/record keeping that has a lot more information that can help you find that. And so that is a good way to figure out, are you one of those companies that is partially exempt? So for example, think of an office environment where you just have employees in the office. You don't likely need to do any type of recording or reporting those 300 logs, those 301s, 300As, right? But otherwise, yes, you do. It does apply to you. The OSHA Act applies to all employers. There's certain requirements on when it applies. Now, if you are in the military, no, but you're not in the military. So OSHA even applies on military bases to private contractors doing things. And so that is something to think about. If you are a government employee, or depending on which state you're in, it may not be, it may not apply, but then you'll have the state that has assumed jurisdiction over that. So no, if you're an employer, you're covered. Sorry.
I like that.
Too bad, so sad.
Covered. Yeah, if you're an employer, you're covered. So if you're an employer, you're covered. Just remember that. No small business exemption. If you're an employer, you're covered, because everybody is covered by, if you're an employer, you're covered by the OSHA Act. So that's
Right.
great. So that was just my, I think my 3 takeaways before going to the next question are, if you're an employer, you're covered. Be proactive, and you talked about all the ways to be proactive, and then check state requirements. Those have been my 3
Right.
big
Oh,
takeaways from
absolutely.
your presentation today.
Right. And so, if you're not sure if you're in a state plan state, the folks in Washington that send in those questions, they're very aware. And I'm sorry. Anyway, but you can type in, right in a search bar, you can type in OSHA state plan states, and it'll bring up the map, and it'll bring up the list. And then you can click on your state and figure out what's in, what's out, what state OSHA has assumed control over, and what federal OSHA retains jurisdiction over. And so that's something. One question I see, Beth, and I wanted to get to this, is it's in the top of my list anyway, is can employee rep be a supervisor? This one company has high entry-level turnover. And I would say no, they shouldn't, because that would be, from OSHA's perspective, a management employee. So if you're a supervisor, a job foreman, something like that, they deem those, or they view those people as management. And so that is not the employee representative. If you have a senior employee who's not in management, that would probably be your best bet. If you're in a place where you have a safety committee, one of the safety committee employee reps could be your employee. I know it's not ideal, but just try and think about that.
That's great. Thank you I think that was Jake that asked that question about the representative, okay. And that's, yeah, that was great. So question from, how do we determine if office employees who occasionally walk through a production floor are required to wear PPE, such as safety toe shoes? That's a great question.
It is a great question. So if you require people on the production floor to wear that PPE, then anybody who's walking through the floor should have that as well, because darned if something won't happen, and something gets dropped on that person's foot, right? That's okay. And I'm a lawyer, so I'm risk averse. What can I say? If they're walking through the production floor, are they walking through the production floor? Are they walking on a path along the edge of the production floor where they're not exposed to any hazards? Is there some kind of a designated walkway? Things to think about. You've got to be able to defend yourself if OSHA comes on site and sees somebody walking through that floor. And that actually raises a really good point, because I had an interesting situation with a client a few months ago where OSHA shows up on site. They're doing, this was a state inspection, but they show up on site and they're doing a general inspection. Sounds like they went beyond the scope of the inspection that they told the employer they was there for, but regardless, they saw doors to an electrical room that only the electrician has access to, and they asked the designated point of contact to open the room, and then they went in to the room. The OSHA inspector went into the room. Now you're supposed to have PPE when you go in there, and the OSHA inspector didn't. But then they cited the employer for allowing the OSHA inspector to go in there without PPE. So, what does that tell you? That tells you that if people on the production floor need to have PPE, then I would recommend that people that don't normally work on the production floor should not be on the production floor. Let's just keep it as an example, because here's a situation where the OSHA inspector went into the room and his response was, well, you didn't tell me to get out of there. And so, I didn't have PPE on. And so you allowed me to go in there, you employer. So that's something to keep in mind, is when the OSHA inspector shows up, they don't get on your site without the appropriate PPE, nor does the employee representative. Make sure everybody's got their PPE on before you do that walk around.
Okay, great question coming up here from Marjorie, and I'm really curious as to your answer on this, Felicia. There are consultation services offered through our state OSHA. Does this keep us from being inspected? For how long? So what are your opinions on the state consultation?
Okay, and this is purely Felicia Watson's opinion. This is all the lawyer disclaimers that you need, right?
Right.
It depends, right? It depends. You're getting consultation services. That's certainly a question to ask the state OSHA person that's helping with that consultation. Does that guarantee that you won't be inspected? No, you should never assume it's going to guarantee that you won't be inspected. There may be, if they're trying to help you get your program squared away, you may have a grace period, but if you have an accident after that or a recordable injury that you have to report to them, they'll probably come in and do an inspection. It just depends on what your circumstances are with your state OSHA person and what kind of an agreement you have in advance, and document what that looks like, whether it's through email, chain, that type of thing. But it just depends on what the circumstances are and what the compliance assistance is that you're seeking. It doesn't necessarily guarantee you won't be inspected in the future. Now, you might be good for 3 months, but what if you have an accident in month 4? They're going to come and do an inspection. They're not going to ignore you.
Kelly is asking about a prototype or sort of a template for the 300 and 300A logs. And then she asks, we currently have a spreadsheet, but I'm not sure exactly what information should be included. And I don't know if you have a resource that Kelly might be able to use.
Yeah, and if you could just give me like 2 seconds.
Sure. And I could look it up too if there is something.
I'll just, it would help if I could spell, but let me put a link.
Oh, that would be great.
Let's see. Oh, here we are. Hold on. I'm going to put a link to the documents in the chat. Can I put that in the chat? Does that work?
Absolutely. Thank you.
Oh, it tells me chat isn't available.
Okay. Well, did you go to if you go to the live event?
Yep.
Q&A, you should be able to publish. Make it an announcement.
Oh, there we go. Ta-da.
Yep.
Sorry,
Yay.
folks. I'm a lawyer. I don't do the text. All right. There's a link to the record keeping forms. Frankly, candidly, it's probably easier to use these unless, and actually you can in some instances, if you have like workers' comp forms, sometimes those will be acceptable. But you could pattern your forms. If you do use a spreadsheet or something like that, you can pattern your forms off of the information that's here. Keep in mind that there are certain instances where you can redact or not include information. Say, let's say there's a sexual assault or something like that. Certain information you are not required to include in that form. So, but that link that I sent you to the forms, each form has its own directions and information. So that's really helpful. And then Casey put in the OSHA.gov/record keeping site, and that has a lot more information, really helpful. Sometimes it can be a little confusing. Go to the FAQs, that will also give you more info.
Okay, great. Do you have any, I know we're coming up on the time here, but question about the staffing and how temporary employees work with a head count. So as a staffing agency, we have been advised that our head count is per job site. Is that still how OSHA is calculating the 10 employee threshold? If you know, and if
yeah, I'm not sure. I would think so. I did look for temporary employees. They do count if they're from a staffing agency, they still count for the employer's number of employees. And so maybe a staffing agency has, let's keep the math easy because I went to law school because I don't do math. You've got 10 different customers where you have 10 employees at each location. These customers are completely different. I think those employees would count towards where they are the customer, but that is something you would want to double check. And OSHA does have information on how to count temporary employees as well.
And then I'm going to try to combine two questions here, which maybe won't work so well, but it's I think it's about triggering sort of when does a an accident need to be reported to OSHA. So one question is, I have an employee who goes to the hospital, not admitted. Is this a reportable accident? And if an employee's hurt on the job, does it automatically go to OSHA? And I've gotten this question too from business owners.
Yeah, so if they go to the hospital, depending on what state you're in, you may still have to report that. If they receive treatment beyond first aid, a good rule is to report it. So, you may have an employee that's, for example, suffering from a heat illness, and they are exhibiting signs and symptoms of heat stroke, and they go to the hospital in an ambulance. You're definitely going to want to report that, or certainly record that. Now, if they're discharged within a couple of hours, then you would mark that as a recordable, not necessarily a reportable. There's a lot of information on OSHA's website on record keeping and when you have to report and when you don't have to report. So that is something to think about. If it's beyond first aid, so they do go to the hospital, my sense is you would definitely need to record that on those forms.
Mm-hmm. Yeah, and I would agree too if they've gone to the hospital. Okay, so moving from sort of injury then now, unfortunately, onto citations here. Casey received 2 citations. He requested an informal conference. That's been months ago. He's heard nothing, or she's heard nothing. So do you have any sense, does the timing vary? I would imagine probably does, between states and...
All right, so here's the question. I guess I have a question back, sort of. So
back
they
to Casey.
Well, kind of. So they received the citation. Did they contest the citation? Because if they contested the citation within that 15 business days of receipt, so say you received the citation on, April 1st, there's no holidays in there. So 15 business days counting the day after you received it. So 15 days starts from April 2nd. You don't count weekends in there. You have to file your notice of contest. And it's simply just responding and saying, I'm contesting citation 112131, right? And you request an informal conference, but you don't get an informal conference. As long as you've filed your notice of contest, then it turns it back to OSHA to submit it to the Occupational Safety and Health Review Commission for filing a complaint and moving forward. I've actually had this come up in a couple instances where OSHA never did anything once the notice of contest was filed. And so that is something to just be aware of and to watch your dates, keep all your records, especially any emails that you had filing your notice of contest. Keep all of that information, keep the information of when you receive the citations. All of that can help you document if you end up with, a congratulations, you owe all this money from a collection agency because it never got prosecuted properly. So if it doesn't get prosecuted properly and you do get a congratulations, you owe us all this money, you can file a motion to reopen with the review commission. But that's why those deadlines are so important. They'll probably ignore you if you've missed that notice of contest deadline.
Yes. Yeah, that's easy. Yes, that does.
That covered it.
That helps. Okay. Yes. Yeah, very much. Yeah. Bottom line is pay attention to your mail and your
email. Oh,
yes.
absolutely.
I mean, right?
Right. Because sometimes it comes, certified mail. Yep. Don't get rid of that envelope. Right. Because you're doing a signature saying, yes, I've received this. And that comes into training, right? Training your frontline people, the people that handle the mail. It shouldn't sit on your desk unopened, right, for 2 weeks. Especially if you're traveling or out of the office. That's kind of stuff's important.
Well, speaking of training, because this might be a good one to close out on, weekly documented safety meetings, are they required for businesses of all sizes? Are there any small business exemptions? And what are sort of best practices when it comes to safety training?
Actually, this is a really good question. And so depending on what state you're in and what size employees you have, you might be required to have a safety committee. So let's go back to Washington State, for example. If you have 10 or fewer employees in one location at any one time, you are not required to have a formal safety committee. You're required to have safety meetings, though. And you have to document these, and you have to keep notes, what was discussed, who did what the topic was, that type of thing. If you have 11 or more employees, you're required to have a formalized safety committee made up of both management and employee representatives, equal measure or maybe even more towards employees. You have to keep notes, you have to keep records, you have to have monthly meetings, those types of things. Other states also require safety committees or safety type meetings. So I think North Carolina is one, and I believe Nevada if you've got a certain number as well, off the top of my head. But if you're having weekly safety meetings, it's a good idea to have, like a toolbox talk, right? Have a checklist. Keep a list of who was there and what the topic was that was covered. And then keep those records, because darned if they don't ask for those when they show up and do an inspection. Usually it's safety committee meetings or safety meeting, trainings, any kind of, like they call them tailgate talks or toolbox talks, depending on what your business is. But if you cover a safety topic in your weekly meeting, it's worthwhile to keep note and who was there and present during that. It's just good business practice. Keep those records. Keep them in line with the rest of your document retention procedures. And depending on what state you're in, you might need to keep them for 2 years, 3 years, that kind of thing.
Thank you. And can one more question? I'm sorry,
Absolutely.
because I got Mr.
It's okay.
Casey's, I got Mr. Casey's question wrong. So I do want to correct this.
Oh, okay.
He didn't contest the citation. He only requested an informal conference. I apologize for that. So I misspoke when I asked the question. Okay. So again, has been waiting now. I think he said several. I need to go back to his question. Quite a while and has not heard anything. So he requested an informal conference.
All right. So obviously this isn't legal advice, but he'll need to take a look at what was sent, how it was documented. But if he has not contested the citation, he may have lost his opportunity, and so he may need to pay those fines. But it's certainly worthwhile, I think, to reach back out to the OSHA inspector and see what's going on. Depending on how long it's been, his ability, the employer's ability to contest those is probably long past, because as I mentioned, requesting an informal conference does not toll the time frame on when you need to contest the citations. So it might be too late for that.
Mm-hmm. That makes sense. That unfortunate.
Yes,
result potentially, but yes, yeah. That's why, again, you've got to pay attention to those deadlines to contest the citation. That's so important. I want to thank you again so much.
Sure, of course.
This was so incredibly helpful. And is there anything you want to say before we turn it over to Casey to close out?
No, I just thank everyone for your questions and for your participation and letting me ramble on about OSHA. It can be a really complex thing. Sometimes it can be pretty straightforward. Always do your due diligence and make sure that you have current up-to-date policies. So I think that's really important. If you're in a state plan state, sign up for updates from your own state, OSHA program, so that you keep track of what they're doing, because sometimes they do different things.
Thank you. Thanks, Felicia, and thank you, Beth, and thank you all for participating today. Visit nfib.com/webinars for all of our webinars on demand. That concludes our program. Thank you for being a participant. Have a great day.